Good morning, everyone. Kurtz and Bill Jones, Kurtz, PL. I wanted today. Let's see it. Screen to affair. Anna, if you could, that would be great. Some technical difficulties. Let's see. For a second. Don't know. Let's see issues. Now that I'm paired up. I'm not. All right, guys, let's try this round two. If my audio is working, please let me know. Apologies if it is not. Anyways, let's try this intro one more time. Thank you for bearing with us through the technical difficulties, and welcome to the September version of Startups in the Law. I've actually lost count of how many we've done. Of how many of these we've done, though I think we're approaching somewhere along the lines of 16, 17, or 18. I'd have to go back and count maybe for next time. But we'll go ahead and get started right now. Anna, would you be able to help me share the slides, or could you let me know if? There we go. Perfect. So let's go ahead and get right into it, since we're getting started a little bit later today. As far as our law firm goes, we have two partners. Matt Jones and I. Matt Jones is based in Oklahoma City. I am based here in Dallas, Texas. And as a matter of fact, we actually do have a third lawyer that's coming on as of November. We've already brought that person in. We are currently training them. They are based out of the Austin Capital Factory. So if you see Trent Cohen walking around or hanging out there, feel free to say hi to him and let him know who you are. That said, if you do have any questions, if you do have any comments, if you have anything to say or any feedback for us on stuff we should do going forward, feel free to email me at kyle@joneskurtz.com. That said, if you have any needs in Oklahoma or anything you'd like to talk to Matt Jones about, feel free to email him at mjones@vergelaw.com. And just a quick explanation on why there's a difference in the emails here. Our law firm in Oklahoma goes by Verge Law Group. Up until recently, we were actually required to go by Jones Kurtz because of the rules related to naming law firms, mainly that we had to name the law firm after ourselves. We're not allowed to use, a corporate law firm name like Verge Law. That said, that rule has actually changed, and we are actually going to be renaming the law firm very, very soon. We're actually in the process of working that out right now and getting the approval from the state of Texas to do so. And I'm actually pretty stoked about that because it means that, I get to make this more about, what we do as a business and less about me and Matt Jones. I've never really loved the idea of actually naming a law firm after myself. So I'm super excited. I'm super excited to actually change the name. That said, here's the mission for why we really do this. We realized pretty quickly and pretty early on, as far as practicing law with tech startups and small businesses, that better legal education led to a better legal foundation for those businesses, which actually leads to more successful startups. I'm proud to say that most of our businesses actually do not end up failing, or at least they don't fail, very early on, like a lot of other startups do, due to financial mismanagement, due to legal mismanagement, and other things like that. Us getting in early on with some of these businesses and our clients, really does, put them a step ahead of the rest of the competition because we're able to coach them on what type of agreements they need, what type of relationships they need to be building, and how to structure those relationships. And so I think overall, partnering or at least pairing yourself up with a capable tech startup lawyer or a capable small business lawyer who can serve as a guide for you, early on is the thing to do. You should align yourself with people who can do that for you, very early on. So as far as what we're going to be going over today. So we're going to go over a little legal and startup news update. We're going to be going over Texas corporations one more time, and then I'm actually going to be going over capital raising and securities laws and going over what you need to know. So bear with us, and if you have any questions about these three topics or have any questions about anything else, feel free to drop them in the chat. I'm going to be monitoring the comments actively while we do this, so that I can try to answer any questions that may be coming up as we're going through this. Okay. That said, legal disclaimer, this is not legal advice for you or your business. I want to be very specific about that. While I'm maybe answering some questions, while I may be, doing a little bit of banter back and forth with the people who are attending this webinar, I want to make sure that, unless you're getting, legal advice that is specifically directed to your business, don't rely on anything you might hear here. Make sure, you follow up and have a conversation with somebody who is capable of officially advising you in the capacity of an attorney that represents you or your company. And then I have to say, there are no absolutes when practicing law. We frame everything based on the facts available and conduct research to reach legal conclusions. We are not sitting here saying that this for sure applies to you, that this for sure applies to everyone. Everything is based on the facts at hand and the circumstances of which we are evaluating. And also remember, you are not a lawyer unless you are one. Even if you are one, I would say, I was actually having a conversation with lawyers yesterday, and those lawyers admitted to me that because they do not practice business law, that they are really not capable of even setting up a basic LLC. They wouldn't know the first thing about it. And so, a lot of times we actually are the lawyer's lawyer. in this situation. I have people who come to us and say, we need some legal help with somebody's estate that we're helping set up. They have a bunch of LLCs that need to get formed. We're the people that would do that, right? So just remember, even if you are a lawyer, you're probably not as capable as we are of doing some of these things, especially because some of the stuff is extremely sophisticated. We're getting down to the nucleus as far as some of the legal issues. So as far as legal and startup news update, I wanted to talk about some recent transactions that we did. And I know we only have one bullet here and it looks kind of sad, but the truth is I wanted to talk about, two transactions that actually closed this past month in the last 4 weeks. One of them was a 750,000 stock purchase agreement. The other was a $3 million royalty-based loan. Now, if you were to guess which one of these transactions actually cost the clients more, what would you think? I think most people would probably say, the $3 million royalty-based loan, but you'd be wrong, actually. The $750,000 stock purchase agreement actually cost twice as much as the $3 million royalty-based loan for our clients. And I thought that was extremely odd. That said, though, I will say, though, how you approach, negotiation, how you approach the transaction and drafting it really does play into how much it's going to cost. The $3 million royalty-based loan, the lawyers who drafted that up and sent it to us drafted it so reasonably that there was virtually nothing I could change. There's basically nothing I wouldn't accept in it, too. And I thought that dynamic was so great. It was refreshing to actually, be able to save a client money and get a really complex deal done for really not a whole lot, right? And it was really nice to, sort of have somebody else, taking the lead on a transaction for once, because a lot of times we're having to steer the entire thing from the get-go, and it's just an absolute mess throughout the entire deal. That said, the $3 million royalty-based loan, to give you an idea of how that really worked, the financing group that actually provides royalty-based loans of that kind, they specifically target profitable businesses and businesses with a lot of cash flow. They do a lot of work, have a lot of customers. Their business is basically fully solidified at this point, and they're not so much in the value stage of growing their business. They're really more in the growth stage. They've reached sort of a level of maturity where they've kind of plateaued off, and they can't really get anywhere unless they do an arrangement like this. And also, this individual client that took the $3 million royalty-based loan, they know for sure that they can pay it off. And by the way, a royalty-based loan is based off of revenue. So basically, the financing group is taking a cut off the top, basically a percentage, and then the loan is actually secured against all of the assets of the business, all of the patents, all of the trademarks, all of the intellectual property, all of the physical, tangible assets of the business. So in the event this loan went into default, basically the remedy would be sell the patents, sell the trademarks, try to sell the company possibly, and then try to sell everything lock, stock, and barrel, as far as the company goes, in order to make the financing group whole again. That said, the interest rates were actually pretty low. They're pretty comparable to what we're actually seeing on standard mortgages. And then on top of that, we were actually seeing quite a lot of the deal itself. Was very straightforward, very easy to read. It was almost like a consumer loan in some respects, where it wasn't, the complexity of it was not actually how complex we normally see such a thing. Now, on the flip side, we have the 750,000 stock purchase agreement. For some reason, that cost the client, twice as much, but it had more to do with how much the client and the other side was negotiating. And one thing to keep in mind when you're negotiating with certain people, especially, it makes sense to realize, where in particular those people are located, and maybe what the culture is of negotiation when those people are going into a business transaction. So to give you an idea, the people that we did this deal for are all based in Mexico, and actually the business that's being invested in, while a Delaware corporation, is actually headquartered in Mexico. and it was a fantastic fintech company. As a matter of fact, it was one of the few transactions where I sat there and said, I kind of want to be an investor in this sort of thing someday. It was one of those things where you just know there's a market for it, you know it has customers, it's earning money, and you're just sitting there thinking, gosh, that's a great opportunity for these people. It would have been really nice to participate in that. That said, originally the deal was for 1.2 million. As far as funding goes, the client we represented wasn't able to get all the way to 1.2, but managed to get 750,000 and ended up investing themselves, along the lines of a quarter million, even though they had already had, a prior investment where I believe they'd invested something like 5 or 600,000. And so, but in some cases, there are ways to reduce the legal fees for a transaction such as this. We use what's called, NVCA model legal documents. There's a national venture capital association that produces model legal documents to help with these transactions. And that was basically how we ran the deal. As a matter of fact, the original term sheet was based off of that. And it actually served as a really great guide for getting this deal done. And and actually in some cases these transactions include, they include, an actual warranty, a promise by one of the companies to the other company that the other company will actually pay its legal fees up to a certain amount. That said, when you look at it, if the company that's being invested in is guaranteeing, legal fees for somebody like me, we all know where that's coming from. The investor pays them, and then they take the money that they just got, and then they pay me, in my invoice. So it's really, effectively my client still paid us. So I do think that's actually kind of a strange thing about these transactions, but it is the way they work. But as far as these deals go, I would say the level of documentation was very similar. There were about 10 documents each for these transactions. And some of these documents a lot of times seem like you could do without them, but we do them anyway because a lot of times this is the expectation of the industry. It's a formality of these sorts of things that we go through. And so sometimes you just got to go through the motions. That said, one thing I do want to say about the differences here. So the stock purchase agreement was done, the stock purchase agreement was done in a company that was going through a Series Seed and is about to do a Series A. This is sort of between the seed round and the Series A. And they had already done they'd already done a seed round where the seed round was done pretty much exclusively via simple agreements for future equity. I will say the dilution was rather extreme on that. Whenever we actually ran the cap table, the pro forma on what this transaction would look like once it was fully done, the dilution was pretty extreme on the original founders. As a matter of fact, once we factored in the post-closing option pool, we were actually looking at, one of the founders was down to like 10%, from like 40 or 45. So one thing to keep in mind whenever you are raising money is that, sometimes you might get to another transaction and realize I really don't have very much of this company left. And if that's the situation you're in as a CEO, I would highly recommend that on the next transaction, so that you don't get diluted into absolute oblivion, you should probably ask for stock options at the next point, or some other sort of grant so that you can or some other sort of grant so that you can actually figure out, okay, I can actually get myself back up to 10 or 15%, something that's meaningful to you. That said, we actually do say once you've done 2 or 3 rounds, it is common for people to get down to about 10%, as far as the dilution goes. You as, a founding shareholder of the business, you try to keep as much as you possibly can. But if you're giving away like lots of safes, or you're doing like $1 million worth of safes, it's kind of difficult when you factor in the discount rates and the valuation caps of those agreements. Okay. The royalty-based loan, by the way, came with a 1% warrant, and a warrant agreement is very similar to, a stock option. It's basically just a right, but not an obligation to purchase securities at a future date, or and we basically settle on a strike price, and then that strike price is set, indefinitely, and then there's a calculation that goes into effect in the event the exercise is made at a later date. So let's say the price of the company goes up, and you know and it's different than the strike price, and the strike price is lower. Then if there's a calculation that goes into effect, and sometimes you can do a cashless exercise, meaning you can give back some of the stock as a form of payment, instead of actually having to pay cash to the company for your stock. So that said, these are very interesting agreements, very interesting deals. The dynamic of each was very different, but I'd say we really enjoyed getting to do this type of stuff. That said, moving on to other news, I'm going to talk about something that last time I talked about this, people kind of blew up on it. They thought I was going all political on this. I want to preempt this by saying the next thing I say is not about politics. It's about employer policies. And it's about employer policies with respect to people coming onto your premises, with how you handle your employees. And so just bear with me. I'm going to explain exactly what I'm talking about here in a second. So as of September 1st, there were 666 new laws that went into effect. And one of them was this law right here. Texans can now carry handguns without a license or training starting September 1st. And that was a serious change to the law. As a matter of fact, nowadays, in some cases, it is actually not legal, or it's not legal for a police officer to simply ask you if you have a gun in your car or something like that. Technically, unless a police officer knows that you have committed a crime, where carrying a firearm might be prohibited, then they're not really even allowed to ask you about that sort of thing. That said, open and concealed carry of handguns is now legal without a handgun license in Texas. You must meet certain other requirements and abide by other laws. But I want to say very specifically that when it comes to employers, there's some exceptions. Okay. On employers, there's really no change here worth noting. Previously under the laws related to, concealed carry and carrying handguns and having, weapons on the premises of an employer, so long as the employer has a clear policy on, the carrying of weapons, the employer can actually prohibit that sort of thing on their property. So let's say, for example, that we have a major employer such as AT&T downtown here in Dallas. Well, AT&T has a very clear policy that I'm aware of, where nobody, unless you're a police officer or security guard that's actually paid by them, they're not allowed to carry handguns or anything. No one is allowed to carry a handgun or even really a knife unless they're a handyman. And so as far as having a weapons policy goes, having that clear weapons policy allows for you to prohibit people from coming onto your property with a concealed or openly carried handgun. Okay. And like I said before, always have that clear policy. If you don't have a weapons policy, create a weapons policy. If your weapons policy isn't clear, it needs to be revised. Have an HR specialist or attorney help you do that. I have forms on my computer that are literally specifically crafted to talk about this sort of thing. Bars and restaurants, handguns still not allowed in 51% bars in the state of Texas. Handguns will now be allowed in restaurants so long as the sign is not posted at all entrances prohibiting handguns and firearms. And this is a key point. You have to, if you're going to prohibit it, like as far as restaurants and bars goes, it is actually where the entrance is. So if you have multiple entrances, you have to have signs prohibiting the carrying of handguns at each entrance. And I was actually talking to somebody about this the other day. A hospital usually has an entrance that's a back entrance or a side entrance for people like police officers to enter through, or undercover police officers, or other individuals that they may be inviting onto their property, where so long as it doesn't have that sign, they can just walk right through, and it's technically then not illegal to carry a handgun there, right? So just a quick distinction, as far as this goes, I know some of the people listening to this are probably like, that's not really an issue for me because I don't have office space. I don't have employees yet. Well, that's not really what I'm concerned about. This is about being forward looking, and it's about you understanding certain things about how to run your business, because at some point, some of you are going to scale up so well that you're going to need to have a policy for this sort of thing, and it's just going to dawn on you one day that you don't have one. And I have actually run into certain individuals who have told me pretty specifically that, hey, we ended up, we allow people to bring, weapons onto, our property or into our office. We allow our customers or our employees to do that. I would highly recommend against that. And the last time I was criticized, by the way, for doing this because people said it didn't have a startup focus. Yes, it does. In the employment context, this applies to every business, including startups, right? So if you have any questions about that, by the way, feel free to email me. I'm not going to talk about it any further. Texas corporations, what you need to know. So one thing I want to say before I get into this, by the way, and I want people to ask questions about this if they do have questions, because I know some of you might have LLCs and you've always wondered, why go corporation? Like, why not just be an LLC? LLC is a little more flexible. Also, some people who have Texas corporations are always wondering, is there really something to having a Delaware corporation or some other sort of state corporation? So this is really key too. If you're a Capital Factory member and you're on the cusp of actually forming a business, you should probably be listening up, because I'm about to give you some very good insight into the analysis I go through whenever I'm starting a business for somebody else. And by the way, I am forming a Texas corporation this week. I've already actually started it. It's just a matter of finishing the documents, and I'll talk about a little bit of what I'm doing there, because that's slightly different than some of the other stuff that I'm doing. So basics of a corporation. It's a different structure than an LLC. It's likely more expensive to operate and maintain than an LLC, and I'll get to that in a minute. We're going to address the difference between closely held and not closely held, par value versus non-par value stock, and then franchise taxes. Whether you pay franchise taxes depends on how much the business earns per year and what type of business it conducts. And I'll go through some of the differences between Texas and Delaware here in a second. Different structure than an LLC, though. One thing I want to say about LLC. So when I start an LLC, there are a few major documents, right? Number one, I get a certificate of formation filed. Once I get that back and I know it's active, I then go draft the company agreement / operating agreement. Company agreement is what we call that for Texas LLC. Operating agreement is what we call it for literally every other state. Texas just has to be special. It's only in Texas's nature to feel special too. As far as, and then the other document is just an initial resolution adopting everything. Aside from that, though, if you have an LLC, sometimes what we put together is called a restricted unit purchase agreement. Very similar to the corporate version of that, but basically it's a vesting agreement. If we want to keep, the founders at arm's length and we don't want people to have all of that equity all at once, we go ahead and restrict some of the stock and make sure that these people have to stick around and work for a long period of time, or at least, a period of time that we consider acceptable in order to get their equity. Especially if you're getting, 25 to 50% equity, it's very common for us to structure that over 2 to 4 year period. Okay. And a lot of times you'll hear people say, 1 year cliff, 3 year vesting. What that really means is we're going to wait a year for the first 25% of your allocated stock to vest, and then the remaining 75% of your allocated stock is going to be issued to you on an individual basis, on a monthly basis, in equal increments. Okay. That's basically how this works. And, we love that structure because number one, if somebody leaves, it allows us to stop, the vesting. It allows us to send a termination notice. It allows us to basically say, hey, you haven't complied with this and we need to fix this. That said, in some cases we allow for cure. We tell people, hey, we know you're taking a little bit of a sabbatical. In some cases we can agree that, hey, we're not going to consider you taking a small step back for your mental health to be a violation of that sort of thing. And so we do take in, to consideration the human factor there. But in general, if somebody does just cleanly walk away and say, I'm not doing this anymore, the one mistake a lot of people make is they don't actually send that termination notice, or they don't tell me about it so I can actually draft the termination notice, because you do have to actually repurchase the stock from those people. So where we go from here, closely held versus not closely held. So this is a distinction that is not actually taught to very many people. And I would say if you were to ask a business lawyer in the state of Texas what the difference between a closely held Texas corporation and a non-closely held Texas corporation, in general, most of those people would never be able to tell you what that means. I'm going to tell you what it means right now. A closely held corporation is a corporation that's held by less than 35 people generally. Also, a closely held corporation does not necessarily need bylaws. Bylaws are are one of those things that we usually establish, establish for non-closely held corporations. And the reason has to do with, we are adhering far more to corporate formalities. We are adhering far more to the meetings related to annual rules, adhering far more to the rules related to board of directors activity and decision making, right? Whenever we want a lot more structure and a lot more rights for the shareholders, what we do is we draft bylaws and potentially a stockholders agreement. So, and there is some overlap between the bylaws and a stockholders agreement. In some cases, you do actually need to make sure that the bylaws do not conflict with the stockholders agreement, because if they do, you're going to have an issue. And we don't want to have any sort of conflicts where we have to sit there and play knockout with certain terms and figure out which document is in conflict with the other and which one is actually it actually takes precedence over the other. That said, I will tell you, a lot of times we draft a stockholders agreement or a shareholders agreement, as they're called in Texas, to say specifically that number one, the certificate of formation, controls. Number two, the bylaws or the stockholders agreement controls. Number three, a buy-sell agreement controls. Number four, the bylaws control. So we can't actually stack the precedents for those documents in the event of a conflict. That said, I, as a lawyer, kind of hate that, mainly because I'm not in the business of being ambiguous. I'm not in the business of being, super vague about contract terms. I'm also not in the business of putting, of putting what I would consider to be, basically a malpractice time bomb into into a contract. I'm very much, I very much want to provide specificity and clarity to people in these agreements. Okay. And then, as far as par value and non-par value stock goes, so in general, the default is really par value. Okay. We don't really do non-par value stock, and I'll get to this in a minute, but par value. So we're basically going to set the par value on the certificate of incorporation, potentially even the class or the series of stock that the par value applies to. And then we're going to go ahead and authorize a number of shares based on those two factors, to that particular class. And that's important for a number of reasons. Basically the par value is the lowest dollar amount that a share of stock can be redeemed for. Okay. And that's probably something a lot of other lawyers don't realize too. I think a lot of other startup lawyers, if you ask them, what does par value truly mean? You'd really be testing their knowledge, because most people have never really even thought about it, nor have they ever been told nor have they ever been trained on what it actually means. Okay. Franchise taxes. So in pretty much every state, you're going to have franchise taxes, or you're going to have an annual report where you have to pay fees. Okay. And that's not germane to Texas. It's not germane to, Delaware. It's something that every state has, because every state uses, corporate filings and annual reports, and, the paperwork that's required to keep a business active as a money-making system for the state coffers. Okay. Franchise taxes, though, whether you pay franchise tax in the state of Texas depends on how much the business earns per year and what type of business it conducts. $1.2 million is basically what you would have to earn in order to pay franchise taxes in the state of Texas. Otherwise, usually, you pay zero in franchise taxes. Okay. That said, if you fail to file your franchise taxes in the state of Texas, you will have to pay a $50 penalty. Okay. By the way, failure to file your annual report in the state of Texas, whether you're an LLC or a corporation, whether you're a foreign corporation or a domestic corporation, you will failure to file the annual report comes with a fee of $50, which actually passes through to the shareholders and through to the members of the LLCs. You need to make sure you're paying that every year, and you need to make sure if you're ready to shut your business down or not going to use it anymore, that you go ahead and shut it down, because those fees are still owed by you in the event you don't. Okay, and they will just continue to rack up. Okay. Does anyone have any questions there? I'm going to stop and take a little bit of a breath. Not exactly the most riveting of conversations, by the way, but as far as as far as basics you need to know, that's actually a good rundown there. So a certificate of formation for a for-profit corporation is Form 201. Obviously, we've gotten this question before, and I hate the fact that I actually have to address this. Um, Switch from an LLC to a Texas corporation. Why don't I talk about that right now, Timothy? Let's go ahead and just answer that question. So, Anna, if you want to go ahead and throw that question up there, I think that's actually pretty important. Um, so, at what point would I want to switch from an LLC to a Texas corporation? So, in general, let's say, for example, that you need to raise money for your business. Okay. Let's say, for example, that you're talking to investors, and you're going from talking to, angels to talking to, you're going from talking to angels and, your early stage seed investors, to talking to institutional investors and people that can provide, more venture capital firm backing. Once you're looking at becoming venture backed, a lot of times we ask the clients, do you want to become a corporation? Because it's going to make having some of these conversations a little bit easier. Some venture capital fund criteria actually requires that the business be a corporation. In some cases, it's specific enough to say a Delaware corporation, because these people will not invest in you unless you are a Delaware corporation. That said, whether you want to switch from an LLC to a Texas corporation depends on the structure. So let's say, for example, you're growing your business, but you want to set up, a more defined equity incentive plan where you can grant employees stock options on a regular basis, where you can incentivize, your hierarchy with stock in your business, or stock appreciation rights, or something along those lines. If that's the case, then switching from an LLC to a corporation does make a lot of sense, because it'll make issuing those things a little bit easier. That said, the question becomes, can I do that with an LLC? Yeah, technically you could, I guess, but but the issue with doing that with an LLC is, a lot of people, especially investors who have done investing before, are going to be a lot more comfortable with the corporate aspect because they understand it more. You're going to experience a lot less friction from those individual investors, because they're going to be far more comfortable with the corporation, with the corporate structure. That said, let's take Capital Factory, for example. A lot of times, Capital Factory, when they're taking shares in a company, I would bet money that they don't really care as much, because they're used to taking stakes in LLCs as well as stakes in corporations. But I would say they're probably, as far as getting later on down the line, probably a little more comfortable with corporations, because corporations, by the way, for investors, make people a little more comfortable, because the structure provides them certain rights. It provides them a way to be able, it provides them a way to actually be able to, enforce their rights at a greater level. That said, LLCs are run a lot more flexibly. They are not run as tightly as corporations are. We have another question, by the way. If you aren't taking outside capital, can you still have restricted stock units, which vest over 2 to 4 years with the Texas LLC structure? Yeah, but we call them restricted unit purchase agreements, right? We're not calling them, restricted stock, because stock is only for corporations. Units of membership interest is what we're granting to people who have LLCs. That's perfectly reasonable. I have documents that do that exact sort of thing, right? That's you just want to make sure that whenever you do grant people restricted units, that they're also signing that they're also signing, a joinder agreement, where they're signing the operating agreement itself, for your LLC, because you want them, once they do have, once their stock does begin to actually vest, you want them to be subject to, your company or operating agreement. Okay. You want them to be subject to tag along rights, drag along rights, rights of first refusal, anything that governs, what happens when, somebody decides to transfer their interest, their membership interest, or decides to try to sell it, right? Um, we want to make sure that these people understand that they are not allowed to just go forth and attempt to sell their membership interest to a third party, without the permission of the company. Okay. Um, that said, as far as 2 to 4 years go for vesting, let's say, for example, you're giving out 5 to 10% of your of the company. If the company is valued a lot, like if the company is valued really highly, then I would lean more toward the 4 years, side of the spectrum, as opposed to two. That said, everything is what you negotiate. Sometimes, you're granting, 5% or 2.5% to somebody in a company. I really don't need that person to be in your orbit for, more than 2 years. Probably, they're probably doing something that's, so limited in its function, or so limited in the value it provides, that 2 years is probably all it will take for them to actually do that sort of thing. So just keep that in mind. Um, Also, I guess the one thing I haven't actually talked about yet is intellectual property assignment agreements. If your company agreement for your LLC, or if your stockholders agreement for your if your stockholders agreement or shareholders agreement for your business does not address, assignment of intellectual property, you need to have a standalone intellectual property assignment agreement. We have a standard form for that. It basically says, you know by virtue of the fact that you're going to be a shareholder and a service provider to this business, you're going to assign all of your intellectual property, for the work that you're doing, to the company. Okay. You want to make sure that's pretty clear, because we don't want to have any sort of common law issue where somebody is protesting, your ownership of their work product, right? And that does happen, by the way. And by the way, in the state of Texas, under the Texas trade, I believe it's the TUTSA, the Texas Uniform Trade Secrets Act, as well as potentially a couple of other acts. As far as intellectual property goes, if you are paying that person, whether it be in equity or whether it be in, cash, the general expectation, absent a written agreement stating otherwise, is that you, as the recipient of all of their work, and as the person who is paying for all of their work, the company itself or the individual who is commissioning that work is going to own it. That said, if there's a paper agreement stating otherwise, or providing some sort of carve out on that sort of thing, then technically the owner is whatever the agreement says it is. Okay. And that is an important distinction. In some cases, we send out intellectual property assignment agreements. And recently we had somebody come to us and say, hey, this guy works for, 3 other startups. He owns shares in all of them. So we need to provide a carve out. Okay. We need to basically say, this is limited in scope only to the work that this person does for this business. It is not, for everything. The person is not so full time that they're committing, every ounce of their work at this very moment to the business. And if anything does change, you do need to make an amendment to the intellectual property assignment agreement saying such a thing has indeed changed. As far as, sorry, excuse me. As far as all these documents go, I think I've already touched on most of this stuff. So par value, this number right here, by the way, is the general standard for which we do par value, 4 zeros before the one after the decimal point. Okay. This is what I do every single time. I really don't deviate from this unless somebody tells me they want something different. Okay. By the way, if you drop a zero on this, it doesn't necessarily affect the amount of franchise taxes you'll pay. All it really does is basically increase what we call the cost basis that the person basically paid for their shares. Okay. Non-par value, issued at a price determined by the board of directors. So it could be $1 or $2, for instance. We usually don't want that because I don't really want to sit here and have to justify, an early determination of the like let's say, we're granting, restricted stock um in a restricted stock purchase agreement. If we just formed the business, then the price at which the person is going to be granted it is going to be this number right here. We don't want to do anything that's along the lines of, issued at a price that's higher than this, and come up with some weird calculation for it, right? Fair market value versus par value, right? Fair market value is very different, by the way. Fair market value is what would a person pay for this if they were, an independent third party, purchaser, right? Somebody who is in an arm's length transaction with you. And determining fair market value is a little more difficult than you would assume, that most people think. Number one, some cases there are safe harbors for determining fair market value. We can have what's called a 409A valuation done, which is effectively just a fair market value, a fair market valuation done on the business's stock at a point in time. Once we do a 409A valuation, that 409A valuation can last for a year unless there's a material change in the company. And a material change in the company is like an investment. Let's say they went from not launching the product to launching the product and having 50,000 users. At that point, you've got loads of users. There has been a fundamental change, and the value of the company is likely changed for the better, right? Aside from that, though, fair market value, I must say, is not par value. That is a major point of confusion. By the way, a lot of people sit there and go, "Whoa, you're putting the value of my company at this? Like, did I tell you that my company was worth that little?" No, you didn't. But by definition, I'm giving you the valuation at the par value, because we literally just started a company, and the company has no assets, tangible or intangible. The company has really no cash yet, and so aside from what has been put into the company by the people who founded it. And so in general, actually, at the point in time that we form a company, this valuation is actually fairly true. Okay. um if there's a different par value assigned at formation, would you suggest doing an amendment to change the par value to, a different decimal point? Not really. It doesn't really have a significant effect on you as an individual from a tax standpoint. It doesn't really have a significant effect on you, from an operational standpoint. There's really no benefit to doing that sort of thing. As a matter of fact, I see nothing wrong with a 0.001 as opposed to a 0.00001. Okay. So I wouldn't feel like there's any need to change there. It doesn't really matter, in my opinion. Um, as far as going forward vesting, I've already talked about this a little bit. Like I said, restricted stock purchase agreements, grant stock to the founders of the corporation, ensure that the stock is vested over time, ensure that stock which is not yet vested is forfeited or repurchased if a founder stops working for the company. Ensure that's, yeah. And by the way, in the event the stock is not yet vested, there's going to be what's called repurchase option language. So it'll say, we can actually structure it to say, in the event that somebody leaves the company, the stock is just forfeited. Okay. That said, I'm really not a huge fan of, I'm really not a huge fan of just forfeiting the stock, because usually, like if I'm doing the calculation based on the par value, which is usually the price that it's granted at, repurchasing it is like $6. All I have to do is send that person money, basically. Um, Basically, we just ensure that the stock, which is not yet vested, can be repurchased. And you need to just make sure you do that in a timely manner. Usually you have 90 to 120 days under the restricted stock purchase agreement to go ahead and do that. If you don't do that, you lose your rights forever, and basically all of that person's stock will basically have vested, to them. Ensure that stock is restricted for being transferred to third parties without the company's consent. That there's basically a term in these agreements that says you're not allowed to transfer this to anyone else without our permission. Also, we usually provide, as far as the repurchase option goes, there's usually exhibits you know, which are basically a stock power and assignment agreement, as well as an escrow agreement that we use in order to, just repurchase, in order to just repurchase the stock without having to do anything further or get consent from anyone. Okay. So moving on. Intellectual property assignment agreements. Like I've said before, these are usually tied in with the RSPAs, right? So there's service provider language in the RSPA and there's service provider language in these IP assignment agreements. We ensure that the IP is held by the company as it's created, ensure that founders and service providers can't take the IP with them when they leave, and then IP is granted to company in exchange for stock. The stock is the consideration here, okay? Like we're not providing them cash, we're providing them stock, and in exchange they're giving us the IP from their work product. Okay. Bylaws and stockholders agreements. Closely held corporations, 35 shareholders or less, may not need bylaws, but we usually recommend having them regardless. This is up to y'all. To give you an idea, I have a Texas corporation that's a client, and they do like $50 million in business a year as far as sales goes. And and they're a closely held corporation because they want to be. They're family run business, as well as like they also don't really have a need for bylaws. They just have a need for a stockholder agreement. And quite frankly, I think bylaws would just irritate them as far as the formality goes. That said, even under a stockholders agreement, there's usually some stuff about annual meetings and calling meetings and things like that. It's still a good idea, even if you're running like a closely held family corporation, to sit down and actually have a meeting with all the shareholders, even if they're family, and just have a conversation about the state of the business. People just want to check in on certain things. And also from an annual meeting standpoint, by the way, in some cases, if you have not complied with the annual meeting requirements, it's not going to require the windup or a termination of the corporation, unless, of course, you've oddly, structured it to say that, which we would never recommend. But if you're ever in court for some sort of issue and you're litigating it amongst the other shareholders or stockholders or people who are running the company, a court might actually require you to have an annual meeting if you haven't had one in a while, because you actually need to have one, and it's a legal obligation under the rules, right? Stockholders and shareholders agreements apply to both closely held and non-closely held corporations. Sets forth the relationship of the stockholders, various voting rights, and other matters where a company has one or more stockholders. A lot of times too, it'll say something along the lines of, the officers of the company, the directors of the company are not allowed to approve an expenditure in excess of X amount for this purpose. And so, and basically that's just to say, they have to put it to a vote of the stockholders in order for us to approve a transaction. So let's say, for example, you want to take out a $250,000 loan. Obviously, the stockholders would be concerned about, the continuity of the business if the company defaults on the loan. They want to have assurance that the company has enough revenue, has enough customers, has enough, XYZ to be able to give the money, to be able to pay down the loan itself and not go bankrupt. And so putting that to a vote of the stockholders is actually a good idea. And sometimes we do that. Okay. And actually, even if it's not required, by the way, it's sometimes just a good idea to notify the stockholders, notify the members of the company, if you're an LLC, that you're, taking out a loan, that you're doing other things that, are not otherwise subject to that, but, obtaining permission for that, or at least asking for the blessing of the stockholders might actually be a good idea. You're not really forfeiting any rights. You're just getting a yes or a no on that sort of thing, regardless, right? Closely held corporations can be, sorry. What am I trying to say here? There's a type of buy with just a share. Yeah, I can get by with just a shareholders agreement instead of bylaws and a shareholders agreement. That's the only distinction between a closely held and a non-closely held. By the way, if you're taking outside investment from people who are really not family members of yours, I would not really consider your company, your corporation, to be closely held. You passive, really non-affiliated stockholders who are, really interested in gain. Okay. So at that point, I would really not consider you to be closely held. I would recommend that you structure your business as non-closely held and have a set of bylaws. Do we have any questions about that, by the way? I'm going to just take a breath for a second. Anyways, going on. Corporate governance. I have an entire folder on our document management system with probably several hundred corporate governance resolutions for different kinds of entities, okay? LLCs, corporations, limited partnerships, things like that. As far as corporate governance goes, this is one of the steps that most people skip. To give you an idea, we had a rather popular Dallas startup fire its CEO the other day. We represented the CEO, and I'm proud to say that we ended up getting that person. We assisted that person with obtaining a settlement. That said, as far as it goes, one of the comments that was made by that former CEO was that nobody cared about corporate governance until they were about to fire me. That's true. They never sat there and actually wrote down the minutes of the board meetings, right? They might have taken notes, but they didn't consider it official minutes. They didn't have, a secretary who was sitting there doing all of that themselves. They didn't formalize it and have all of the board of directors, agree to it or sign it or have a secretary certificate for it. And so, and that's pretty true. It's pretty par for the course. As far as corporate formalities go, a lot of times most people aren't worried about adhering to corporate formalities until such time as they're making a significant decision. I would recommend, try to run a tight ship. Okay. Adhere to the corporate formalities, actually go through the motions on this sort of thing, because you never know when somebody's just going to go sideways on you and they're just going to go, oh, you did that wrong, or, that pissed me off and I'm just going to sue you over it. You want to be able to stand on firm legal footing in the event that's the case. And I really do like the ability of being able to just unemotionally say, look, I've held an annual meeting ever since this business launched. And I've taken board minutes for every board meeting that's ever been held. You want to see that, I'm willing to share it with you. Because at that point, you're going to look like a shining star of litigation, because you're going to be able to sit there and give all that to your attorney, and that person's going to go, this person accused you of fraud and misconduct, despite the fact that you were actually adhering to literally every law that you are subject to. Good luck with that, right? So as far as I really do like the idea of this. That said, I don't really pitch this too much to our startup clients, because I know that they're running on a tight budget. A lot of these people are bootstrapping, so I would say don't try to spend too much money on corporate governance. But if you're making a major change, if you're issuing or granting stock in the business, granting stock options, what have you, it does really help to have resolutions for this sort of thing. You really do want to make sure that people are approving that, and that you're getting consent where apologies, that you're getting consent where consent is needed. Okay. Major events, contracts, and actions taken by the company should have resolutions adopting these from time to time. Major ones, loans. Like I'm just going to go through the list one more time, by the way. I know I'm repeating myself, but I want to hammer this home. For some people, loans, stock grants, investments, by the way, all need to be papered up with resolutions at some point. There's also a greater level of documentation that needs to be required, and you need to comply with securities laws, for certain stock grants, as well as investments. Okay. Let's see. All right, attendee questions. This is from a while ago, I'll tell you. But I added this back in, because I wanted to talk about this. What happens if you have a lawyer as a co-founder? Number one, I would recommend against it. But if you have a lawyer as a co-founder, if that person knows way more than you about structuring companies, especially like if it was me as a co-founder, I would, like if I was a co-founder and the other person wasn't, I might actually tell that person, hey, you really do need to. I would probably tell that person, hey, you probably do need to actually go through and find a lawyer to represent you to do this. because I just don't want you to feel like you've been taken advantage of. Okay. Other questions, how much stock to issue? Um, that's really a decision based on, how much. That's really a decision based on how much work that person is going to provide and what their role is. If the person has a really limited role and they're not really doing very much other than providing code for a certain period of time as an employee, then at that point motivate that person with a little bit of equity, but don't give them too much. Um, if that person's taking on the COO role, give them a bit, because they deserve it, and you want them to stick around for 3 or 4 years. You want them to really help grow and grow into that chief operations officer, chief operating officer role. How much stock to grant to founders and service providers? Like I said, it all depends. It's what you negotiate with those other people. Figure that out and talk to other people about what they've done, and just gather data on that and then make a decision. What's the difference between Delaware and Texas corporations? I try not to talk up Delaware too much, but the truth is, a lot of people are very comfortable with Delaware because Delaware's common law is slightly different than Texas's common law. So Delaware's common law, a lot of times will look to the four corners of the contract. If they are what we call a very contractarian, legal. They have a very contractarian legal culture in Delaware, where they're going to look to the language of the contract. They're not really going to look at anything else unless what has been done is actually indeed governed by some common law precedent or some other law. Okay, and as far as protecting investors, as far as protecting the founders and the CEO and the COO and the directors of the company, so long as these individuals have done everything right, they can generally, these contracts will generally protect them quite a lot. Okay, and as far as protecting you in the M&A context, it does help to be a Delaware corporation if you are undergoing a merger or an acquisition, because if it's just a matter of reading the law and applying the law to the agreements, when it comes to drafting these transactions. And as far as having a Delaware corporation goes, we generally say it does a better job of protecting you than a Texas corporation. That said, if you want to look at some competing places, Wyoming and Nevada are making some moves to try to become like Delaware. Personally, though, I like Delaware a little bit better, mainly because I like the way the cases read. Their body of case law is actually very sophisticated, and it's actually very nuanced, to the point where in some cases they're making decisions on a razor's edge almost, it feels like. We have a question here. If someone wants to invest a certain dollar amount in my startup with no real role in the company, family, how do you figure out how much stock to issue them? It's a good question. So as far as you're talking about friends and family around, right? Or just friends and family investments. As far as giving them stock, we don't want to give them too much. If you want to sort of push off the conversation as far as equity goes, you can grant them what's called a simple agreement for future equity. And then once you do a later round, at some point in time, if you do a stock purchase agreement or a convertible note later on, or some other transaction, then at that point, the instrument will convert and they'll end up getting their equity later on. That said, if they're saying they want equity in your business in exchange for cash, take a look at what they're putting in. If it's significant, then you may have to give out I don't know 5 or 10%, but try not to give out 40% or 30% or 20%, because you want to make sure that sophisticated investors who are doing due diligence on your business don't see any red flags there. And if a family member has like 40% and they only gave you like 10 grand or 20 grand, the investors are going to sort of shake their head and tell you, hey, I appreciate the opportunity, but we're going to have to pass. is just not a good fit for us. And really what they're saying is you just gave out far too much equity to that individual who didn't provide very much value. And, as far as investment goes, it's okay to give family, friends and family, an opportunity to invest in your business. A lot of times we do that via a simple agreement for future equity. That said, I do understand and want to acknowledge that there are challenges when it comes to explaining a simple agreement for future equity to an individual who is not that sophisticated. Okay. To an individual who does not do startup investing. That said, one thing I do want you to remember though is, you know, remember that your family are going to be people you see on a regular basis, are going to be people who ask you about the business. Make sure you don't take money from people who are expecting massive return on it. Okay, if the expectation there is they think that your business is going to go gangbusters, manage that expectation by making sure that they know that this thing could go to zero and they'd lose everything, and that you are not reimbursing or guaranteeing losses. Okay, a lot of unsophisticated family members will want their money back in the event they buy an equity stake in your company, and they need to understand that that will never be the case. You are actually by law not allowed to do that sort of thing. Okay. Aside from that, I would also say if that family member is well to do, if they're technically a millionaire, then they're a sophisticated investor. They're accredited as far as an investor goes. I would highly recommend. I would actually highly, if they're the type of person where, a $25,000 investment to them is walking around money, they'd spend $25,000 if they had it, then by all means go ahead and strike a deal with them, because they're the type of people who will be very kind to you at Thanksgiving, and will not really ask about how the business is doing, aside from just checking in with you. And that said, even if you do take an investment from a family member, I highly recommend on a monthly or quarterly basis getting into the habit of emailing your investors. Okay, because people just want to know, they want to be kept in the loop. And by the way, Michelle says, those investors are not that type, they're not well to do. So, if you're falling under Rule 506B, which says you can have 35 non-accredited investors, just keep in mind, you have a certain level of disclosure that needs to be made to these people in order to comply with securities laws. They technically, you need to give them, a fairly good look at what your business is and what it does, and disclose a bunch of the risks to them. That said, just keep in mind that, if they're not that type, and they're not the type of people who could ever stand to lose that kind of money, I would highly recommend just saying thanks, but no thanks. It's not that I don't like you as a family member. It's that I just don't want to have to, tell you that we failed, right? That sort of thing. Series A transaction. So I've talked for a good bit about fundraising already, so I think this is a natural segue. According to a Wing venture capital report from April 2020, the median amount of money raised leading up to a Series A was 3.3 million, up from 3 million in 2018, and 5.5x from and 5.5 times the $600,000 median of 2010. Now, I want to caveat this by saying there is loads of data out there, to the point where when I was searching for this information, I literally could not find anything that I thought was reliable as far as numbers go. So I just had to pick a data source. And so I just want everyone to understand that if you've seen different numbers, just remember that I'm not taking these as the end all be all of numbers. They're consultants who are highly paid to crunch the data on this. And they come up with the best guess on what the actual number was, because some of this stuff is actually not reported. And I believe a lot of this stuff is just based on what appears in Edgar filings, and what appears in Reg D filings. Okay. Seed financing leading doubled from 2016 to 2020. Median 2020 2.2, and then going on down the line, you can see that median in 2010 was $1 million. Obviously, the dip here can be explained by the pandemic. I think that's pretty obvious. That said, as a matter of fact, a lot of the reports actually said that in 2020, venture capital fundraising actually grew. So I'm not entirely sure who's right or who's wrong here, but I'm actually of the opinion that it probably was actually stagnant. It was probably closer to being stagnant based on the reports that I can find, because some people are saying that it grew and some people are saying that it didn't. Um, you know, based on our practice, and for private financing and investing, I would say that it was, that it grew by a little bit, but not by too much. Okay. Seed round pre-money valuation median, $11 million, up from nine and a half in 2018. Pre-revenue seed rounds are becoming exceedingly scarce. 2/3 of companies in 2019 closed seed financing generated revenue at the time, up from only 9% in 2010. So basically, the trend is actually skewing towards safer investments here. Basically, I think the industry is actually getting tired of a lot of people who are sitting here and saying that, oh, this is going to go gangbusters. We're going to be able to make money off of this. It's also, people are realizing, as we do more and more of these, how to actually ensure that we make money on the investments more regularly. That said, we are seeing people get a little bit scared away from exciting investments. To give you an idea, we have one client where, gosh, it's the type of business that if you invest in it and it goes, and it goes on to be worth a lot of money, or it goes on to an exit, it will have been the only company that does what it is doing. There will have been absolutely no competitor in that space. And as a matter of fact, that company launched and there's still no competitor in that space. And so this person actually has not just a moat, but something that they came out with and basically said, okay, well, we technically don't even we don't even have competitors at this point. We don't have anybody that we can peg a valuation off of as far as what we're doing. As far as the style of the application that they have developed, the only thing adjacent to it isn't even in the same industry. And so and we actually do get pushback on the valuation for that business because it is so unique. The typical size of a Series A here, median Series A stats, 12 and a half, 11.9 in 2018, and then 5.1 in 2010. I do think people are getting a lot more sophisticated at running venture capital funds, and there are way more VC funds out there, by the way. Median pre-money valuation stats, 30 million, in 2019, and then 2018 was 28 and a half. I didn't have numbers for 2020, by the way, on this from this source. Revenue generating Series A companies, 77% in 2019, up from 75% since 2016, but up significantly since 2010, 7.7. I would say, a lot of ventures fizzle out if they can't seem to generate at least even a little bit of revenue, you know. And it's not that they need to be profitable. A lot of these Series A companies, by the way, note that I'm not saying profit generating companies. Most of these investors could not care really whether or not the business is profitable. As a matter of fact, they almost don't want it to be, because they want to know that the business is actually pushing so much money back into its organic growth. They want to know that it's pushing so much money back into its organic growth that it's growing their customer base so rapidly that eventually, there will be that break even. There will be that, line where, the revenue and the expenses sort of converge and equal out, right? And so when you're looking at revenue generation for Series A companies, we're not. By the way, I don't have stats on how much revenue those companies generated, as well as what you need to know about any sort of, like, if we do see a number on how much revenue Series A companies are generating, just so you're aware, that does not really get disclosed in securities filings, because securities filings allow companies to opt out of disclosing how much money they make, or how much money they make as far as annual revenue. Series A, process due diligence. So the diligence process is fairly important. And basically, let's say you're a $10 million startup or a $20 million startup. There's software that we call virtual data room software, VDR, and basically all of your documents are going to go into the VDR. Okay, all of the documents are going to be put in there, and there's going to be separate categories for all of that stuff, and everybody's going to sit there and go, okay, like put your certificate of incorporation here, put any trademark stuff, any intellectual property stuff, put any equity incentive plans and employment agreements, and all this other stuff. They're going to give you a list, and it's really just a checklist, man. As far as providing that information, you want to make sure that you provide a very organized, a very readable set of documents. You want to make sure that you have everything at your disposal when somebody asks for it. Okay. And I think that's one of the things that some founders don't do. Also, don't be the founder that doesn't have, some sort of cloud backup for any of this. Also, I do not recommend that you store literally everything on Google Drive. Unfortunately, Google Drive has a feature where you can literally just, delete in mass all of the documents on the drive itself. So I know businesses that are generating $1 million in ARR that are exclusively using Google Drive and its suite of other applications, and that just bothers me. I literally, like, it just makes me nervous and anxious thinking about it. That said, though, you want to have a cap table, and by the way, if you are valued at less than $1 million, you can get on Carta pretty easily. Okay. Carta is free to people who are, valued at $1 million or less. All right. Equity incentive plan, AKA employee option pool. I call it an equity incentive plan because employee option pool, I don't want to just provide the ability for these people to grant stock options. I want to provide the ability for these people to, grant any type of instrument. Okay. Whether it be a warrant, whether it be a stock option, restricted stock units, restricted stock purchase agreements, stock appreciation rights. There's tons of different things you can do. Okay. Major contracts, you're basically, depending on the valuation of your company, whatever company you might be doing a financing with, or whatever company that's requesting documents from you so they can do due diligence, is going to ask you for major vendor agreements to show that you have relationships and partnerships, and basically verify the information you're talking about. If you cannot produce a decent contract for some of these things, some of these people are going to say, thanks, but no thanks. We don't want to work with you, because the problem is we can tell that you whipped this contract up from Rocket Lawyer, and it's a mess, right? So if you're engaging in major vendor agreements, get a lawyer involved so that your documents look very clean. And also keep in mind, you want to prepare these documents so that the documents look really good, because if they look really good, it increases the acquisition value for your business, right? Legal is an investment as far as a merger or acquisition goes. If you invest 2 years before that merger or acquisition takes place, and your documents are absolutely spotless as far as errors go, as far as compliance issues, you're gonna be able to argue with the people on the other side that, no, our valuation is actually higher. You're not going to find another company that has cleaner docs, right? And then financial statements, you're going to have to be able, you want to have, QuickBooks or some other financial statement generating software, accounting software that allows you at a moment in time to produce your year to date, as well as your historical financials going all the way back to the beginning of the company. You want to be able to have all of that sort of stuff, and you want to be able to just drag and drop it. Okay. Term sheet. Once the due diligence process is done, it makes sense to go through and draft the term sheet. A lot of times we actually do this simultaneous, or we don't finalize the term sheet until such point as we've actually reviewed all these docs and made sure that everything looks okay. Major points: pre-money, post-money valuation. A pre-money valuation is the value of your company today. The post-money valuation is the value of your company today plus the value of the investment. So if your business is worth $1 million and you're selling $250,000 worth of stock, the post-money valuation is $1.25 million. It's the pre-money valuation plus the investment amount. Okay. Pre-closing versus post-closing cap table structure. You're basically just going to put together a pro forma, see how it shakes out. Okay. Equity incentive plan structure pre and post close. You'll potentially have to have a conversation with the investor about whether to expand the equity incentive plan to bring it back up to a certain amount so that you have enough shares in the equity incentive plan to issue to additional service providers. Transaction type, type of stock, price per share, right of first refusal, offer. Obviously, price per share is like the most important term. Restrictions on business activity and decision making by management. Sometimes whenever we do a deal like this, the term sheet will include a right for the investor to obtain a board seat. And in some cases, some of the restrictions will say, we're not going to do a transaction where, like some of the restrictions will say, board decisions are limited, and some of the decisions, including salaries for the CEO who is also a founder. Salary determinations have to be made by a disinterested board member, right? So basically, it can't be made by one of the individual original stockholders who founded the company. Preemptive anti-dilution rights. Once we get to Series A and Series B, I would say anti-dilution does become a factor. Though I've heard some really good arguments, by the way, against anti-dilution. Best argument I ever heard. This guy, we were negotiating with him, and I was basically just saying to him, hey, a lot of people in this industry, especially, funds like this, are getting anti-dilution. We want anti-dilution. We can technically set a floor for it to where, hey, we're buying, 6%, but we'll agree, not to go any lower than 2.5 or 4 or 5, right? And this person's response, which I loved and I had to respect because I couldn't really argue against it unless I just flat out said we're not doing this deal unless we get anti-dilution. He said, really, if you want to be protected or insulated from dilution, you can purchase more shares in the company. But we just generally don't want to give out anti-dilution because we don't want to have to give it to anyone else, which I thought was a good idea. Whenever you do give anti-dilution, people will see that in these agreements and they'll sit there and say, all right, so as far as, and they'll basically just say, as far as, this preemptive right, the anti-dilution right, if you do it at Series A, you'll be doing it beyond. And it does actually create some complication. It does help to use software to lock in anti-dilution, I'll tell you. So other major rights, might include rights of first, other major rights might include, warrants, right? So let's say, if we're doing a stock purchase agreement, but the person wants a stock purchase agreement plus a warrant to buy a certain percentage of shares. And usually the warrant will include anti-dilution language. Okay. And that's sometimes a thing in larger private equity transactions. I wouldn't say it's as common in smaller venture capital transactions, though we might see it every now and then. Every deal, by the way, what we say is every deal is different. No deal is really the same. That said, there is a standard structure for these deals. And to give you an idea, so, the equity incentive plan structure pre and post close, we recently had somebody try to get us to agree to a pre-closing option pool, which was a pre-closing, equity incentive plan of 10%, which was interesting because usually it's a post-close. Usually we issue 10%, to an equity incentive plan, or authorize 10% under an equity incentive plan after the close of the it's usually after we, do the deal and after the money has been sent, right? And that actually ensures that the investors don't get diluted unnecessarily, you know, don't get diluted unnecessarily. It, and as far as, well, actually, sorry, I apologize. I got that switched around. Oh gosh, give me one second. So yes, it's usually pre-closing. I apologize for getting that wrong. Sorry, it's been a bit of a morning for me. Usually we do it pre-closing so that it's already on the books prior to the transaction going through, so that we know what we're getting. Okay. Sorry, I think I'm getting this wrong. Anyways, I'll clarify this in an email. As far as pre and post close, I'm sort of just having a brain fart right now. I haven't eaten breakfast. Um, uh, as far as uh, as far as drafting transaction documents, um, this is often where things get more difficult because we're actively negotiating these documents, and you know, we're addressing things that are not covered by the term sheet and things that might be expanding on certain terms that we were looking at in the term sheet itself, but not necessarily contemplating in full. So we just want to make sure we're honoring the language of the term sheet, right? You want to be reasonable but firm on these things. I've sat there before and just straight up told people no on certain things because I said no, we're not agreeing to anything that's different than what we would have otherwise agreed to in the past, and also we sort of want some uniformity to these transactions so that there's no gotchas, there's no red flags in the event of an acquisition later, right? Be willing to get creative to solve problems, though. If there is some weird stuff that's way back in the company's history, potentially address those. Try to make sure that those aren't deal breakers. And also, as far as you yourself as the founder negotiating these deals and like trying to get the deal across the finish line, I always say try to be a deal maker, not a deal breaker. A lot of lawyers can be a deal breaker. They're the type of people who just are obstacles in these things and are just sitting there negotiating to negotiate and earn their fee, and just doing some rather bizarre things as far as making decisions on behalf of their client. To give you an idea, I once had another lawyer strip out basically all of the economic terms that would have allowed a simple agreement for future equity to make any money. They basically took out the discount rate and the valuation cap. And it was effectively just an interest-free loan almost, um, for like 100 grand. And I was sitting there thinking to myself, hey, thanks, but no thanks. We're not going to agree to any of that. Because there's nothing in there. There's nothing in there that actually makes it so that we would make money on this transaction and be rewarded for our risk. So just keep in mind, like some lawyers will try to do the gotcha. I think those lawyers actually suffer some reputational harm when they do that, though, because they're not being reasonable, right? Execution and post closing. Execute all documents, including all consents required. Ensure that every signature is accounted for. You want to make sure that everybody signs. Follow up with people who don't sign. Happens way more often than you think. Post close. Ensure company does its securities filings, Reg D, or other types of filings if necessary. This is lawyer territory unless you want to take it upon yourself to do that. We have documents where we basically say we're going to have our client sign a limited power of attorney. I'm going to go file a Reg D on their behalf. We're going to get this thing done. Ensure the cap table is finalized and given to all stockholders. Ensure a new 409A valuation is done since company's new valuation has undergone a material event requiring a new 409A valuation. 409A valuations can cost anywhere between $5,000 and $15,000, depending on how complex the business is. What happens if one of the documents contains an error? Fix it. I actually saw a document the other day, and I thought this was a fantastic idea. Somebody apparently included a clause that said, so long as it is a typographical error, so long as it is something that is not a substantive error, as far as like a dollar amount or anything like that, then the CEO, would have the unilateral right to just fix that error. Like somebody added that into an agreement, and I loved it because I was like, yeah, if anything is truly wrong with this, then at that point, we don't have to go back and get 20 separate signatures again to amend it, right? Um, it's also easier, by the way, as far as admitting that, something is wrong or that an error was made. If an error was made, just say we amended it to correct the errors. We messed that up and we knew it and found out about it, not necessarily knew about it. You know, like it. Well, like I said here, it's better to say, we're amending this to correct the errors than it is to say, we knew about it, but we never bothered to correct it, because that's just admitting that you're wrong. And also, it's almost an admission of willful misconduct. If something's wrong, you need to fix it. um Take things more seriously than you did before. um oh, by the way, going back to the pre and post closing option pool thing, it's pre-closing. Sorry, the as far as an option pool existing, you want it to be pre-closing first, because that way it doesn't dilute the investor immediately after the investment. I apologize for any confusion on that matter. Thanks for bearing with me on that. It just took me a little while. I was actively going through my head about the dilution mechanics on such a thing. The problem with it, if you do it after the investment is made, you're potentially just going to end up diluting. You're potentially just going to end up diluting, uh, the newer investor, a little bit more than they otherwise would. So once you start taking money in the hundreds of thousands or millions, the likelihood of founders, CEOs, and C-level executives of startups being accused of misconduct and fiduciary duty violations goes up. Buy directors and officers insurance. This is pretty common stuff. That said, directors and officers insurance does not protect you in the event a director is suing another director, or a director is suing an officer of the company. It doesn't protect you there. It really only protects you in the event you get accused of some sort of shareholder suppression sort of thing, where it's not all of the directors that were immediately involved who are also shareholders. Buy large commercial general liability policies. It's pretty standard stuff. You should go do that. Ensure multi-level dispute resolution clauses are in your C-level employment agreements, and that everyone has an executive employment agreement if they're an officer executive. We don't necessarily do that at the seed stage, because it's kind of not necessary at that point, especially if we're still figuring out, what the roles are and, what this is, as far as a company. But once it's a Series A or a Series B, we kind of know. And so it does make a lot more sense. That's what I'm not saying we don't ever do it at the seed stage level. If it's a large seed round and the seed round is $1 million, maybe it makes a lot of sense to do that, because it just makes sure that it just ensures that everybody is going to still be at arm's length with each other. um, have indemnification agreements for founders and board members to limit their liability. You could do this at the very beginning, but it really matters whenever an officer itself becomes a member of the board of directors. Okay. You want to indemnify the directors with an indemnification agreement at that point. Paper of board meetings with official minutes, and it, by the way, the indemnification agreement really does matter once once you start having investors, once you start having investors take a board seat, right? Paper of board meetings with official minutes, board decisions, official written consents of the board meetings and the votes, and make sure you take copious notes of the meetings yourselves, or better yet, record them if you can. You're allowed to record these conversations. That said, some people don't like to be recorded. There are also third-party services that do this for a living and just conduct these things as a matter of law, and provide opinions to you on whether or not they've been complied with. So if you're getting to the point where everybody is just like, it's a hassle to even hold these things, or you're getting to the point where you need to actually be a little more polished in your appearance because your business is becoming way more valuable, then at that point, maybe hire a third party service to train you how to effectively do more sophisticated board meetings. Aside from that, that was the last slide. Does anybody else have any questions for us? So I want to say thank you for attending. I know there probably weren't very many people here today because we had to reschedule, but I appreciate those who did attend. That said, we are going to be holding another one of these at the beginning of next month. First Tuesday of every month is the day that we do these, and we'll send out another reminder. to those people who want to do this. Thank you very much, though, and I look forward to seeing you again. Take care, everyone. Bye.